It is 9:44. A federal judge is restricting the use of tear gas in protests following a lawsuit filed by the ACLU. The case dealing with federal officers, specifically immigration agents, using tear gas on protesters in Portland.
All right, so we're going to bring in our chief legal analyst, Khalif Rhodes, once again to talk about this. This has been going on for a while. So what does this latest ruling mean exactly?
This is a continuation of a previous ruling from this same judge regarding this same case, regarding these same types of officers. It's a class action suit, so let me start with that, and I'll talk about why I inserted that portion at the end. But it's not just tear gases, kinetic projectiles, pepper paintball, paintball guns, pepper spray, tear gas, soft nose rounds, lethal, less lethal shotguns, flashbangs, a number of things. But they also they said where you can shoot them, not at the head, neck, or torso, which was during the hearing. Folks alleged that that's what they were doing, not just to individuals. These are non-violent protesters, but also the press. And they cannot use them just to disperse crowd. So there was testimony that they were just shooting them at people randomly. Some of the images that were presented in the hearing showed officers standing on top of the building shooting down at people that weren't doing anything except for just standing there taking pictures. Those are the allegations, and that's why the judge ruled the way that they did to continue the previous injunction that was put in place.
So clearly there's a fine line between the federal officers protecting federal property, ICE buildings, and so forth, and then crossing the line and violating First Amendment rights.
Yes, I 100%. There's a clear line, and the judge hit on that. When I talk about injunctions here a lot, you guys have heard me say that a number of times. Irreparable harm, this likelihood of success on the merits, balancing of the equities in this public policy. And so this was a excellent opinion in terms of walking through those steps. It's 34 pages. I'd say 26 of the pages are walking through the injunctive standards. So when the judge talks about irreparable harm, the loss of First Amendment freedoms for even a minimal period of time unquestionably constitutes irreparable harm. So there you go. He answers that right out the gate, that this not a question that this is irreparable harm. When talking about balancing of the equities in the public interest, it's always in the public interest to prevent a violation of a party's constitutional rights. So to your question, Jason, yeah, your First Amendment rights are protected, and because they're protected, it hits on 2 of the 4 factors for an injunction.
Khalif, as far as what you're talking about, the class action lawsuit, I want to give you a chance to expand on that, but also talk about how the judge may now, or had to have weighed what the rights are of these law enforcement officers and ICE officers, immigration officers, to protect, these buildings, also to be able to use the tools available to them to disperse crowds, but also respecting the First Amendment, Fourth Amendment rights of the protesters.
Well, regarding the officers, and he mentions that as well, that you have to be in imminent fear. There has to be some threat. There has to be some harm. If these are non-violent individuals and you're perched above and shooting down on them, there's no imminent fear to you, and so that was thrown out instantly. And regarding the class action and why it brought it up, they were arguing, the defendants were, that even if the judge would agree to continue an injunction, limit the scope of what you're attempting to do to only these 5 defendants. And the judge said, well, not going to do that either. Why? Because they're a class. This class was already certified, and because this class was certified, I'm going to allow it to be to everyone, not just to the 5 folks, that you just can't decide to not shoot at them people, but it's anyone that's a nonviolent person that's coming before them. The last quote that I'll read, and this is something that I thought was pretty interesting, that he says, in a well-functioned constitutional democratic republic, free speech, courageous news gathering, and nonviolent protests are all permitted, respected, and even celebrated. In an authoritarian regime, this is not the case. Indeed, a democracy is only as strong as its tolerance for dissent. Our nation is now at a crossroads. Those are the types of things that the judge was contemplating when making this ruling.
And real quickly here, if you're defending the federal government as this case plays out, how are you doing that?
I'm arguing that we were in imminent fear, that there was a threat, that not only was I protecting the building, but I was protecting my officers, that when they're firing these things, that there has to be some threat. If I can't point to a threat, then I'd have no leg to stand on. I mean, and so the videos and pictures were damaging. The shots and targeting press in the head and in the neck area, then when they were posing no threat, would be extremely hard to defend. But that's my only argument, that, hey, I'm defending myself, and that's why I'm justified in using that force.
All right, again, our chief legal analyst, Khalif Rhodes, breaking that down for us. Khalif, thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.